Good morning. Welcome to the special session of the California Supreme Court. Holding oral arguments on the fine campus of the University of San Francisco is not our traditional venue, of course, but we regularly bring our court hearings to communities around the state because we are committed to informing Californians about their courts and about the role of the judiciary in our democracy. My colleagues and I pursue these opportunities to engage our communities because we believe that the strength of our democracy depends upon the public's recognition of the interrelationship and independence of the three branches of government.
The USF Law School was founded in 1912. This special session is part of a year-long celebration of our 100th anniversary. I have many fond memories of my 7 years here on the hilltop. Actually, I was with the Jesuits for 11 years, and I'm deeply grateful. They were outstanding teachers in every possible way. I am grateful for the training, for the guidance, for the value-centered education that they gave me.
Calling the morning calendar for the special session of the Supreme Court of California at the University of San Francisco School of Law on Tuesday, February 5th, 2013.
What are the issues before the court?
Yes, and the issues before the court is whether a municipality may ban what state law has made lawful. And I think that that's the core issue.
When you say, counsel, that
the core of this case to me is really land use regulation, zoning ordinances, and the authority that's historically been vested in the municipalities for land use purposes. And so what I'm getting from your argument is that we are to read between the lines because it's not expressly stated that somehow the municipalities' traditional police powers of land use has been impacted and severely restrained by the Compassionate Use Act or the MMPA and these later amendments, when it doesn't expressly speak to restricting municipalities' traditional authorities over land use.
Well, let me speak about the traditional, the word that the court is using, traditional, and I refer the case to the court, the case of Big Bear Lumber versus County of Santa Cruz, because that problem is addressed right there in that case, Your Honors. The land use traditional legislation has never, ever, ever been seen as giving authority to local governments to ban what state law makes lawful. It doesn't include that, and Big Creek Lumber makes it very clear. The only thing that you are looking at when you're talking about traditional is location. They certainly have extraordinary authority to control this. They can set up rules as to how you come into establishment. They can say it's going to go in one particular part of town versus another. They can limit them by numbers. They can set up rules to suspend permits after they've had problems with them. Thereafter, they have extraordinary tools to fight this. But traditional land use has never, there is not one case from this court or from the Court of Appeals that has ever said traditional land use includes or functions by a local government includes banning.
The main thing I thought that they were arguing was the difference between prohibition and regulation, where they said it was a regulation, but in practice it worked as a prohibition because those people who have the medical marijuana cards wouldn't be able to access anything in their city. So in that matter, it's a prohibition on their state right. And I thought that was really interesting argument.
It does seem as if that the state law gives a bit of an edge or an advantage to the local governments because the police power is of local governments to regulate for the public welfare is something that is well established under our state constitutional system. And if the state legislature wants to preempt the local governments from regulating, then they need to clearly indicate. And the truth is, in the two laws that the state of California has passed, one with the voters, one from the state legislature, the state has not clearly preempted.
So you would agree that at issue here is whether the state laws in question remove or restrict the city's pre-existing police power?
Yes. The source of that police power is under the state constitution, and specifically it's Article 11, Section 7. And that provision has been adopted in many decisions by this court. But it essentially provides that the constitutional authority that we have there is to enact ordinances for the public safety, the public welfare, within the discretion of that legislative city council. And that authority is recognized except to the extent that it is preempted by general law.
Right. So the significance of the police power reposing in the Constitution is that the people, when they enacted the Constitution, have reserved to themselves that police power. It is not conferred by the legislature.
That's correct. This court's decision in DeVita versus County of Napa recognizes that principle, that it is not a delegation of authority from the legislature. It is independent of the legislative authority. It is constitutionally sourced.
Well, what about point 8.3, which does speak of municipalities can regulate? Is the common sense meaning of regulate meaning to prohibit?
Yes. This court's decision in the Metro Media case has a phrase that we often use in interpreting the municipal ordinances, and that is, every form of regulation necessarily includes a prohibition. And that's just a common sense application of the word regulate. Whenever we regulate as municipalities, as the court recognized in Metro Media, we're prohibiting at some level. We would respectfully ask the court to uphold the lower court decision by the Court of Appeal, finding that there is no state law preemption by either the Compassionate Use Act or the Medical Marijuana Program Act.
I would like to please state the following with regard to the fiscal versus city and county of San Francisco case, which I think is very instructive here, because the court there uses all of this court's precedents on the issue of bans and strikes down a total ban on handguns in the city and county of San Francisco with even less preemption, or I should say state legislative purpose, language that is in there. And if I may quote, if the preemption doctrine means anything, it means that a local entity may not pass an ordinance, the effect of which is to completely frustrate a broad evolutional statutory regime enacted by the legislature. That is exactly what has happened here.